Section 1 of Elementary Catechism on the Constitution of the United States, for the use of schools, by Arthur Joseph Stansbury. This LibriVox recording is in the public domain. Part 2.
Question. May slaves be imported, that is, brought into the United States?
Answer.
No. Whoever engages in the slave trade is a pirate.
Question.
May slaves be held, that is, owned and made to work by citizens of the United States?
Answer.
Yes.
Question.
If they escape from one state into another, may the state into which they flee set them at liberty?
Answer.
No.
Question.
Suppose any American citizen is seized and put in prison. May be he kept there as long as those who seized him think fit?
Answer.
No. He may get a writ of habeas corpus.
Question.
What is that?
Answer.
It is a command from court by which the jailer is forced to allow the prisoner to be brought up before a judge, that the cause of his being put in prison may be examined into, in order that if there is no law to keep him there, he may immediately be set at liberty.
Question.
Must this command be given whenever it is applied for?
Answer.
Yes, except at certain times when this privilege is suspended, that is, interrupted for a time, but not taken away.
Question.
When may this right of having a writ of habeas corpus, which belongs by the Constitution to every citizen, be suspended?
Answer.
Only in cases of rebellion by our own citizens or invasion of the country by an enemy, when the public danger is so great as to require persons to be kept in prison who might otherwise be set at liberty. As soon as this extreme danger is past, the right of habeas corpus must be immediately restored.
Question.
Is this a very great and important privilege, and ought all Americans to guard it with the greatest care?
Answer.
It is one of the greatest rights of a free man, and Americans must never surrender it under any pretext if they value and would preserve their liberty.
Question.
May a man's children be punished by law for his offense?
Answer.
In some countries where a man has been guilty of treason, that is, making war against the government, a law is passed called a Bill of Attainder, by which his children are prevented from being heirs to him or to any other person, and if he belonged to what in those countries is called the nobility, and his children would have belonged to it too, they are prevented, nor can they nor their children, nor their children's children, recover this privilege till an act is passed for that purpose. No such law can be made in this country. It is expressly forbidden by the Constitution.
Question.
May a citizen of the United States be punished for doing what, when he did it, was not forbidden by any law, but against which a law was passed afterwards?
Answer.
No. A law that attempts to punish actions that were done before the law was made is called an ex post facto law. This is also expressly forbidden by the Constitution.
Question.
When a direct tax is laid, that is, when Congress order that a certain sum of money must be paid by each citizen for the public use, what is the rule by which it is to be collected?
Answer.
The census or public counting of the people.
Question.
May any money be required to be paid on goods exported, that is, carried out from any of the states?
Answer.
No.
Question.
May any law be passed giving to the ports of one state, that is, the places where vessels arrive and depart with goods, a preference over those of another, so that goods coming to some ports shall have less duties to pay to the government than the same goods coming to other ports?
Answer.
No.
Question.
May vessels coming from sea with goods which they wish to deliver in one state be obliged to land those goods or to enter them, that is, give an account of them at the custom house, or to pay the duties on them in another state?
Answer.
No.
Question.
When a vessel leaves the ports of one state with goods which she is carrying to sea, can she be obliged to clear those goods, that is, give an account of them at the custom house in another state?
Answer.
No. Each state may carry on its own commerce without the interference of any other state.
Question.
In what way can the money of the United States be drawn out of the Treasury, or place where it is kept?
Answer.
It can be drawn out only by authority of a law of Congress, and such a law is called an appropriation.
Question.
Must a full account be kept of all monies received into the Treasury and paid out of it, and must this account be published, that is, printed and sold from time to time?
Answer.
Yes.
Question.
You said that in some countries a part of the people are called nobility. What does that mean?
Answer.
Almost all Europe was once under the power of Rome and formed part of what was called the Roman Empire. This empire was attacked, overrun, and at last conquered entirely by a hardy set of people who came from the north in vast numbers. These people were commanded by their chiefs or kings, and when the countries which they invaded gave up fighting and yielded everything to the conquerors, the whole of the land was divided into portions and given by the king to his chief officers, who divided it again among their followers. These great officers were called by various names or titles, as dukes, earls, counts, etc., and when they died, their oldest sons were called by the same titles, which continued in this manner to descend in certain great and rich families. It is these families which are now known in most countries of Europe as nobles, or the nobility, and they have great privileges over other citizens.
Question.
Can any families be thus distinguished from the rest in this republic?
Answer.
No. No title of nobility can be granted here. The only titles among us are those which mark a person's grade in the army or navy, or his office in the state.
Question. May any citizen of the United States receive a title of nobility from the king or prince or government of any other country? Answer. The government does not interfere with private persons, but no person holding any office of profit or trust under the Republic can accept of either a title or sum of money as salary, an office, or even a present from any such prince or government without the express consent of Congress. Question. Why is this? Answer. To guard against any foreign prince getting influence over those who are in power among us by bribes of any kind. A title would be a better bribe to some men than money. Question. You said that when the states entered into their agreement by which they set up a general government over them all, they had each a perfect right to govern themselves as free, sovereign, and independent states, and that they gave up a part of their power to the general government and kept the rest of it in their own hands. What are the powers which they gave up? Answer. The power of making treaties, that is, bargains or agreements with other nations, alliances, that is, agreements with some other country that the two shall help each other in something they wish to accomplish or in avoiding some common danger, and confederations, that is, agreements among several different countries that they shall all join together in some object for their common benefit. None of these acts can now be performed by any one of the states separately, but must be done only for the whole by the general government. Question. What other powers did they give up? Answer. The power of making treaties, that is, bargains or agreements with other nations, alliances, that is, agreements with some other country that the two shall help each other in something they wish to accomplish or in avoiding some common danger, and confederations, that is, agreements among several different countries that they shall all join together in some object for their common benefit. None of these acts can now be performed by any one of the states separately, but must be done only for the whole by the general government. Question. What other powers did they give up? Answer. The right to grant letters of marque and reprisal, the right to coin money, both of these have been explained, the right to emit bills of credit, that is, to issue printed promises to pay certain sums of money on the credit of the state, the same as a bank issues banknotes, to make anything but gold and silver a lawful tender in the payment of debts. Question. What does that mean? Answer.
When one man owes another and goes to him and offers him money to the full amount of his debt, that is called a tender or offer. And if the money is such as the law says shall pass, it is a lawful tender. And if the man refuses it, he can never sue the other for that debt, nor is the debtor obliged to pay it. Now, though money is commonly made of gold and silver, yet sometimes a government may make a law by which certain printed notes are to pass the same as gold and silver, and after such a law, that kind of printed notes are a lawful tender to pay debts with. This kind of paper was issued by Congress in our Revolution. The states, by the Constitution, gave up the power to do this, and now it can be done by the general government only. Question: did the states give up any other power? Answer: they are forbidden by the Constitution, in the same manner that Congress is, to pass any bill of attainder or ex post facto law, or grant any title of nobility, nor can they make any law which shall impair the obligation of contracts. Question: what does that mean? Answer: it means that when a bargain has been made between any two parties, by which one agrees and binds himself to do some particular thing not then forbidden by law, the state in which this agreement or contract was made shall not afterwards make any law by which the person who thus bound himself shall be set free from any part of that bargain without the consent of the other party, with whom he made the contract. Question: what else are the states forbidden to do? Answer: they cannot lay any duty on exports or imports. Question: may they not lay enough duty to pay for the expenses of collecting the duties laid by Congress? Answer: yes, but no more. And if more is received than is wanted for this use, it must be paid into the Treasury of the United States. Question: may any sum of the states lay a tonnage duty? That is, require a sum of money to be paid by every vessel entering any of the harbors in that state? Answer: no. Question: may they keep soldiers whom they pay in time of peace? Answer: no. Question: may they keep ships of war in time of peace? Answer: no. Question: may one state enter into an agreement with another state? Answer: no. Question: may they make a treaty or agreement with any other nation? Answer: no. Question: may they make war? Answer: no, not unless an enemy has entered their bounds, or is in such danger of entering that there is no time to wait for the aid of the general government. Question: why did the states give up all these powers? Answer: because they could be better protected by one powerful government ruling over them all united than they could have been if they had remained separate. And if they would have such a government, they must consent each to give up a part of their own power in order to make it. If the general government had no power, it would be of no use. Question: who executes the laws which Congress have made, that is, who takes care that everybody shall obey the laws? Answer: the President of the United States. Question: can he make the law? Answer: not at all. These two powers, of making law and executing law, are kept by the Constitution entirely separate. The power that makes the law cannot execute it, and the power that executes the law cannot make it. One of these powers is called the legislative, and the other is called the executive power. Question: is there any advantage in this? Answer: certainly. It is the great safeguard of freedom, because if the one makes oppressive laws, the other may refuse to execute them, or if the one wishes to do tyrannical acts, the other may refuse to make a law for them. Question: how does any man become President of the United States? Answer: he is elected, chosen, by the people of the United States. Question: How is this done? Do the people themselves at once choose the president? Answer: No, this might lead to great confusion. But the people choose the legislatures of the different states. These legislatures appoint electors, and those electors choose the president. Question: Explain this more particularly. Answer: You know what is meant by the legislatures of the states. They consist of persons chosen in each state to make the state laws. These persons, when met together, appoint in any way they think proper a number of persons who are called electors, because they afterwards choose the president. Question: How many of these electors of president are appointed in each state? Answer: As many as the state has members in both houses of Congress. For instance, a state which is entitled to 2 senators and 8 members of the House of Representatives must appoint 10 electors of president. A state which has 2 senators and 20 members of the House of Representatives must appoint 22 electors. Question: May any person they please be appointed an elector? Answer: Not every person may. Senators of the United States, members of the House of Representatives, and all persons who hold any office of trust or profit under the United States are incapable of being electors of the President. Question: Why? Answer: For fear any President of the United States might use improper means to get himself chosen again, when his time of service should expire. The President has frequent opportunities to see the members of Congress and persuade them, and as he himself has the appointment of most persons who hold offices, he might threaten to remove or promise to keep them in their places and thus destroy their freedom of election. Question: How do these electors proceed? Answer: The electors appointed by each state meet in the states that appointed them and vote by ballot for the President and for another officer called the Vice President of the United States. The electors all meet on one and the same day in their several states. The day is fixed by Congress. Question: What do you mean by voting by ballot? Answer: When it is wished to conceal the manner in which each particular person voted, and yet to know what is the opinion of the greater number of voters, the voters, instead of speaking their minds, put each a piece of folded paper into a box. These papers are called ballots, and when all have voted, these ballots are examined and counted. Question: May both the persons whom the electors of any state vote for, as President and Vice President, be natives of that state in which they are voted for? Answer: No, only one of them. The other must be a native of some other state. Question: How do they distinguish which of the persons is voted for as President and which as Vice President? Answer: The ballots are taken separately on different pieces of paper, and it is besides written on the ballot whether the person is voted for as the one or as the other. Separate lists are kept in which they put down the names of all the persons who are voted for, either as President or as Vice President, and the number of votes given for each. These lists are signed by the electors and then sealed up and sent to the seat of government directed to the President of the Senate. For the greater security, 2 copies are made. One of them is sent by the mail and another by a messenger, sent for the express purpose of carrying it. Question: What does the President of the Senate do with these lists? Answer: He opens them in the presence of the Senate and the House of Representatives, who are all met in one hall to be present when the votes are counted. Each house appoints some of its own members who unite in a committee and count all the votes. When the person having the greatest number of votes for President is declared to be the President, and he who has the most votes for Vice President is declared Vice President of the United States. Question: Suppose no one person has a majority, that is, more than half, of all the votes for President. Is the person who has the most votes considered as chosen? Answer: No. Question: What is done in that case? Answer:
The House of Representatives immediately proceed to choose, by ballot, from those persons, not more than 3, who stand the highest on the list of votes for President, one to be President of the United States. Question. Are they bound to choose the person who has most votes? Answer. No. They may take either one of those 3 persons who have the most votes. Question. Do they vote on this occasion in a different manner from what they do on all other occasions? Answer. Yes. In choosing the President they vote, not by single members, but by states. That is, each state has 1 vote only, whether its representatives are many or few, and a majority of the whole number of the states is necessary to a choice. Question. Must all the states vote? Answer. All may vote if they are present and desire it, but if only 2/3 of the states vote, the election is good. Question. Suppose the House of Representatives cannot, or do not, choose anyone. Must there be no president? Answer. In that case, the Vice President must perform the duty of President. Question. If neither of the persons voted for by the electors as Vice President has a majority of all their votes, what is done? Answer. The Senate then chooses one of the 2 persons who have the most votes. A majority of the whole number of senators is necessary to the choice, but 2/3 of their number is sufficient to vote. Question. May any person be chosen President of the United States? Answer. Not every person. None may be chosen unless he has been born in the United States or was a citizen when the Constitution was agreed to, nor can such a one be chosen if he is less than 35 years old or if he has not resided within the United States for 14 years. Question. May any person be chosen Vice President? Answer. No one may be chosen as Vice President who is forbidden by the above rule to be chosen as President. Question. Suppose the President of the United States should die, or should be put out of office, or should resign his office, or should from any cause be unable to do the duties which belong to it, what is to be done? Answer. His duties must then be performed by the Vice President. Question. But suppose the same thing should have happened to the Vice President also? Answer. Then the Congress must declare by law who shall perform the duties till another President is chosen, or till the President is again able to perform them himself. Question. Does the President receive anything for his services? Answer. The honor of filling so high and honorable a station by the choice of a great and free people, and the glory of leaving his name in their history as the faithful friend and father of his country, is, of itself, enough to fill the wishes of the most aspiring mind, and no doubt the place would be sought as eagerly as it now is, though not a dollar should be given to the man who fills it. But because his station exposes him to great expenses, he is allowed a salary sufficient to meet them. Question. What is the amount of the President's salary, that is, the sum of money paid him by the United States every year? Answer. It is at present fixed at $25,000. Question. May he receive any other money from the United States or from any one state? Answer. No, he is expressly forbidden to receive any other sum of money than his salary. Question. Why? Answer. Lest, if any state allowed him money, he might be led to favor that state more than the others, and lest, if he was suffered to receive other sums from the United States, he might amass so much money as should make him a dangerous citizen to a free country. Question. Does the President take any oath before he enters upon his office? Answer. Yes. Question. What is an oath? Answer. It is a solemn calling upon God, who knows the hearts of all men, and will call every man to account for his conduct in this world, to bear witness that what a man says is true,
or that what he promises he means to perform. Question. What is the President's oath of office? Answer. It is in these words: I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Question. What are the powers which belong to the President? Answer. He is Commander-in-Chief both of the Army and Navy. Every officer of both, from the highest to the lowest, is obliged to obey his orders. Question. Are the officers of the militia obliged to obey them? Answer. Yes, whenever the militia are called out in the service of the United States. At other times they are under the command of the governors of their own states. Question. Has he any other powers? Answer. Yes, he may grant reprieves and pardons for offenses against the United States. Question. What is a reprieve? Answer. When a person has been tried, found guilty, and condemned to be punished on a certain day, a reprieve is a putting off of the punishment to some other time. Question. What is a pardon? Answer. It is the delivering of a condemned person from the punishment of his offense. A reprieve only delays punishment. A pardon prevents it entirely. Question. May the President do this in all cases of offenses against the United States? Answer. In all cases, except cases of impeachment. Question. What other powers has he? Answer. He has a very solemn power, that of making treaties for the United States with other nations. Question. Why is this so solemn a power? Answer. Because a treaty is the supreme law of the land and usually concerns matters of great importance to us all. Question. Is nobody joined with the President in this power, or may he make any agreement he thinks fit with other nations? Answer. This power is so great and weighty that the Constitution will entrust it to no one man. Even the President cannot make a treaty without the consent of the Senate of the United States, nor is it sufficient that a majority of the Senate agree to it. 2/3 of all the senators who are present when the vote is taken must agree to any treaty before it is binding on the United States. Question. Has the President any other power? Answer. Yes, the powers of nomination and appointment. Question. What do you mean by this? Answer. When persons are to be employed to do the duties of certain great public offices, none can be so employed but those whom the President first nominates, that is, proposes to the Senate, and whom the Senate consent to have employed. And when the Senate has given this consent, the persons cannot act in their office till they receive orders to do so from the President. Such an order is called their appointment, and when put in writing, it is called their commission. Question. What officers are appointed in this manner? Answer. Ambassadors and foreign ministers, that is, persons sent by the United States to the government of some other nation, either to prepare some public treaty or to reside there as the representative of this country. Consuls, persons sent by this country to reside in the ports of other nations to protect our commerce, that is, to see that our vessels, our sailors, and the property of our merchants are properly treated there according to the treaties and laws of both countries. Judges of the Supreme Court, and all other officers of the United States, except those who are expressly ordered by the Constitution to be appointed by some other person than the President. Question. May the President appoint any officer without the consent of the Senate? Answer. Yes, if Congress makes a law giving him the power, but this applies only to inferior officers, that is, such as have other officers over them. Question. May Congress give the appointment of such officers to any other than the President? Answer: Yes. It may give it to the courts of law or to the heads of departments. Question: What do you mean by the heads of departments? Answer: This name is given to certain officers who have the chief care under the President of the four great branches of the government called the executive departments, and who are called the Secretary of State, the Secretary of the Treasury, the Secretary of War, and the Secretary of the Navy. Question: Are the duties of these officers declared by the Constitution? Answer: No, but by a law of Congress. They are, however, persons of great importance in our government. The Secretary of State attends to everything which concerns our affairs with other nations, and also to those of the general government with the governments of the different states. The Secretary of the Treasury attends to all that concerns the money of the United States. The Secretary of War manages the business of the Army, and the Secretary of the Navy that which concerns our vessels of war. All these officers are, however, under the control of the President. He may require their opinion in writing on any subject that belongs to their different departments, but he is not bound by it. He may also dismiss them from office. Question: Suppose any of the officers whom the President has appointed by the consent of the Senate should die, or should resign his office while the Senate is not sitting. What is to be done? Answer: The President may appoint another person in his place who shall hold the office till the end of the next meeting of the Senate. Question: What are the duties of the President? Answer: He must from time to time give information to Congress of the state of the United States. Question: Does he know what is the state of the nation better than the members of Congress? Answer: Yes. His office is such that he has a better opportunity of knowing it. Each member of Congress resides only in one state, but the President resides at a spot in the middle of them all. It is the duty of all officers below him to send reports of the various affairs in which they are employed to one or other of the heads of departments, and these lay all the knowledge they thus obtain before the President for his direction and assistance in the many and great duties he has to perform. He is, therefore, of all other persons best acquainted with the general concerns of this nation. Question: When does he lay this information before Congress? Answer: He makes a very full statement of it when they first meet, in what is usually called the President's speech, and from time to time, while the two houses are met, he sends to each of them messages in which he gives more particular statements than he could do in his first general speech. Question: Suppose Congress wish to know from the President something which he has not told them in his speech or messages, may they call upon him to communicate it? Answer: Yes, and if he does not think that the public good requires it to be kept secret, he always answers the call and gives them the knowledge they desired, if he can do so. Question: Does he do more than communicate information to the Congress? Answer: Yes. His duty is also to recommend to them such things as he thinks will be for the advantage of the country. Question: Are they obliged to do as he advises? Answer: No. They pay respectful attention to what he says to them and listen to the reasons he gives in favor of the measures he recommends, but they are at full liberty to follow their own judgment in all cases. Question: Is it to be desired that Congress should always comply with the advice of the President? Answer: No, for then his advice would, in time, come to have the authority of a command. It would be the President and not Congress who made the laws, and the liberty of the country would be in the greatest danger. There is no more dangerous despot than one who can make his will obeyed and yet preserve the forms of a free government. Augustus Caesar ruled the whole Roman Empire with absolute sway, yet he did everything by resolves of the Senate, as if Rome was free. Question. Suppose some very important matter should happen while Congress is not met. Can the President call them together? Answer. Yes, he can call either both houses or only one. If any law is to be made, both houses must be called. If only a treaty or an appointment is to be made, the Senate only need be assembled. Question. Suppose when both houses are met, they should find themselves unable to agree about the time at which they will adjourn, that is, cease to meet. Can the President end the dispute? Answer. Yes, by adjourning both houses. Question. In that case, when are they to meet again? Answer. At any time the President fixes when he adjourns them. Question. What other duty is required of the President? Answer. He must receive all ambassadors and foreign ministers, that is, persons sent by other nations to make treaties with us or to reside here as representatives of their own government. Question. Has he any other duty? Answer. Yes, he has one great general and constant duty for which all this power is put at his command, and it is to take care that the laws shall be faithfully executed, that is, whatever Congress orders shall be done, and that whoever disobeys the laws shall be punished. Question. May he be punished himself? Answer. We have already seen that every civil officer of the United States may be impeached by the House of Representatives, tried before the Senate, and, if guilty, may be turned out of office. The crimes for which this is done are chiefly treason and bribery. Treason, we said, is making war against the United States by endeavoring to resist or overturn the government. Bribery means the unlawful taking of money by an officer for doing or omitting some act of his office. Question. Does not every officer receive money for doing the duties of his office? Answer. Yes. The law allows him a certain sum, but a bribe is something more than this, given him not by the United States, but by somebody who wishes him to favor them in the exercise of his power as a public officer. It is wicked to offer a bribe. It is still worse to accept one. Question. Can there be no bribery but by means of money? Answer. Yes. Bribes may be offered in various shapes. Any benefit or advantage offered to an officer for an improper end is a bribe. Question. What do you understand by a court? Answer. A place where a judge sits to hear and determine causes according to law. Question. Are courts necessary? Answer. Certainly. Wherever laws are made, there must be some way of determining when they have been disobeyed and of causing those who disobey them to be punished. This is the use of a court and of a judge. When one person believes that another has broken the laws, to his injury or to the injury of the public, he may cause that person to appear before a judge and have it determined by witnesses whether he has broken the laws or not, and if he has, he is forced to suffer such a punishment as the law directs. Question. Are there courts in every state of the United States? Answer. Yes. Each state appoints judges of its own to see that its laws are executed. Question. Are there also other courts belonging to no particular state but to the United States? Answer. Yes. Question. Are all these courts equal, or is one superior to another? Answer. They are not all equal, but in each state some of the state courts are set over others, and so it is with the courts of the United States. Question. Why are they not equal? Answer. Some are set over others, in order that if one makes any mistake it may be corrected by that above it. When a citizen thinks he has been wronged in a lower court, he may take his cause to a higher one. This is called an appeal, and if in this higher court he still thinks he is wronged, he may appeal to a court higher still, until he has got to the highest court in his own state. Question: can he take his cause from the state courts to the courts of the United States? Answer: no, not unless his cause has to do with a law made by a state, which, as he supposes, is contrary to the Constitution of the United States. That question can be settled only by the Supreme Court of the United States. Question: suppose his cause has to do with the law of the United States and not a state law. Answer: he must go at once to the courts of the United States. Question: what are those? Answer: they consist of one Supreme Court, the highest of all, and of such other courts under this as Congress may from time to time establish. Question: has Congress established any? Answer: yes. It has appointed some which are called circuit courts of the United States, and others below these which are called district courts of the United States. Question: what judges sit in the circuit courts of the United States? Answer: the judges of the United States Supreme Court. Question: what judges sit in the district courts of the United States? Answer: district judges. Question: what kind of causes are tried in the courts of the United States? Answer: any cause must be tried there in which the dispute is about the true meaning of any part of the Constitution. Question: what else? Answer: all causes under the laws of the United States. Question: any others? Answer: yes, all which depend upon treaties between the United States and other nations. Question: what other causes? Answer: all in which ambassadors or other public ministers or consuls sent to the United States by other governments are parties concerned. Question: what others? Answer: all causes which concern the taking or detaining of ships at sea, and all which concern crimes committed at sea or in harbors or rivers, or in forts and dockyards belonging to the United States. Question: what other causes are tried in these courts? Answer: all disputes in which the United States is a party, all disputes between one state and another state, all in which one of the states sues any person that is the citizen of another of the states, all in which a citizen of one state sues a citizen of another state, and all in which citizens of one and the same state lay claim to land under grants of different states, all in which one of the states sues a citizen of some foreign country, and all in which citizens of the United States and citizens of any other country sue each other, but not where citizens of one state sue another state, or where citizens of subjects of a foreign state sue one of the states of the Union. Question: must all causes of these several kinds be begun in one of the inferior courts of the United States, or may any of them be commenced at once in the Supreme Court? Answer: all cases which have to do with ambassadors, public ministers, and consuls, and all of those in which one of the states is a party, may be begun in the Supreme Court. The others, after being commenced in the inferior courts of the United States, may be removed to the Supreme Court by an appeal, but this is submitted to the regulation of Congress, who may determine by law when it may be done and in what manner. Question: how are the judges of the courts of the United States appointed? Answer: by the President, with the advice and consent of the Senate. Question: how long do they remain in office? Answer: during good behavior, that is, until they resign their office or are turned out of it for some great offense. Question: Why are not judges elected from time to time, like members of the House of Representatives and senators? And why may they not be removed from their offices unless they are proved to be guilty of great offenses? Answer. If judges held their places at the mere good pleasure of the people, they would be greatly tempted to act in a partial and improper manner in order to please those who chose them to office and to keep their favor. But when they know that no man or number of men can turn them out of office so long as they do their duty, they administer justice without fear and with an equal regard to all who ask it. Question. Why then should not legislators hold their office in the same way? Answer. Because they make the laws, while judges only explain and apply them. It would be very dangerous to liberty to give our lawmakers power for life, and they require restraint lest they should become our tyrants. Therefore their time of office is made short, so that if the people think them unwise or unfaithful, they may refuse to give them the office again. Question. You said that the use of courts was to determine when the laws have been disobeyed and causing those who have disobeyed them to be punished. How do courts answer this end? Answer. When a person is charged with having done something to his neighbor or to the state which is forbidden by law, the fact is judged of by a jury. Question. What do you mean by a jury? Answer. A company of citizens, chosen by lot, and who have no interest in the matter, who listen to the proofs brought against the person accused, and who then agree among themselves whether the accusation has been proved or not. When they declare this agreement in opinion, it is called their verdict, and according to this, the cause is decided. Question. Is this a wise regulation? Answer. Certainly. The trial by jury is a most precious privilege, as it secures to every man a fair hearing, and is the best safeguard of his liberty, property, and life, all which might be taken from him by a partial or corrupt judge, if that officer alone had to decide on the guilt or innocence of those who are tried before them. Question. Does a jury decide in civil suits as well as in criminal prosecutions? Answer. I do not understand the difference between them. Question. By a civil suit, I mean one citizen's calling another into court to answer him for some injury committed against him. By a criminal prosecution, I mean a citizen's being brought up by a public accuser for some crime committed against society at large, and for which he is liable to public punishment. Answer. A jury decides in both cases. When an officer of the United States is impeached, the accuser is the House of Representatives, and the jury is the Senate. But in ordinary prosecutions and suits, the jury consists of 12 persons residing near the place where the act was committed. Question. May an accused person be tried in a different state from that where the criminal act was committed? Answer. No. Question. Suppose the act was committed at sea or in some other place not within any one of the states of the Union. Where must the trial be held? Answer. Where Congress shall have appointed by law. Question. Ought all the public acts of a state and all of its courts and officers to be recorded in writing? Answer. Certainly. Not only to preserve a remembrance of them, but that these persons who are affected by these acts may be able to show proof of them, and if injured, to obtain redress. Question. When such a record is made in one of the states, and a copy of it, duly proved, is given, must that record be received as proof by all the other states? Answer. Yes. But Congress may determine by law in what manner the record shall be proved for this purpose. Question. When a citizen of one state goes into any other state of the Union, may be he treated as if he was a foreigner, or may any difference be made between his privileges and those of the citizens of that state? Answer. No. he shall enjoy every privilege which they do. Question. If a person charged with a crime in one state shall flee from justice into the bounds of another state, is he safe from pursuit and trial? Answer. No. If the governor of the state where the crime was committed applies to the governor of the state where he has taken refuge, the latter shall cause him to be delivered up. Question. Suppose a slave in one state shall run away from his master and flee into another state. Does he thereby become free? Answer. No. On application of his master and proof of his being a slave, he must be given up. Question. How many states were there which revolted from Great Britain at the Revolution? Answer. 13. Question. Did they all agree to the federal constitution at the time it went into operation? Answer. Not all, but the rest came in soon after. Question. Was it then expected that other states would be formed and join the Union? Answer. Yes, and provision was made for admitting them. Question. By whom were they to be admitted? Answer. By Congress. Question. Is their number limited? Answer. No. Question. Or their population? Answer. Not by the Constitution, but Congress has determined that a district or territory containing 60,000 inhabitants may be received into the Union as a state. Question. Then that number of people in any of the states may be erected into a new state? Answer. No. No new state can be formed within the limits of a state already formed. Question. May two states be united by Congress into one, or parts of two states be erected into a third state? Answer. Not unless the legislatures of both such states give their consent. Question. When the colonies separated from Great Britain, was their territory all peopled? Answer. No. Large tracts of land in several of the states remained in its natural wild state. Question. When the states united under the Constitution, what was done with those wild lands? Answer. They were given up by the several states that owned them and set apart as common property for the good of the whole. Question. Who has power to govern these territories as they become settled and to sell the land to settlers? Answer. The Congress of the United States. Question. Have they since been extensively settled? Answer. Yes. Many new states have been formed within their limits, and many more are expected to be. They are in the meanwhile divided into several distinct portions called territories, each of which has a form of government suited to its amount of population, and a delegate in Congress with power to speak but not to vote in that body. Question. Has any state the right to set up a monarchical form of government for itself, that is, a government where the supreme power is in the hands of a king? Answer. No. When the colonies united, they were all republics. The new government they formed for the Union was republican, and they then secured to every state which had joined or should join the Confederation a republican form of government. Question. Who is to see that this regulation is carried into effect? Answer. The Congress. Question. Does Congress secure any other privilege to the different states? Answer. Yes. It must protect them from invasion by an enemy. This is one of the most important benefits of our Union. Each state has the protection of the whole. Question. Should unruly persons in any of the states attempt by violence to resist and overturn the state government, and should they gain such strength that the state is not able to quell them, must Congress interfere? Answer. Yes, if applied to by the governor or legislature of such state, but not to prevent a peaceable alteration of the laws attempted in a regular and proper manner. Question. The majority of the people of any state may certainly alter its laws, provided they do not violate the Constitution, but may the Constitution itself be altered? Answer: yes. The Constitution, being nothing more than an expression of the will of the people of the United States, is at all times within their own power, and they may change it as they like, but it ought not to be changed till it is very clearly shown to be the wish of the people. Question: how is this to be found out? Answer: when 2/3 of the members both of the Senate and of the House of Representatives shall agree in opinion that an alteration would be proper, they may state such alteration and propose it to be considered by the people of all the states. The alteration must then be considered by the legislature of each of the states, or by a convention in each state, which is a meeting of persons chosen by the people for this particular purpose. And if 3/4 of the states agree to the amendment, then it becomes a part of the Constitution. Question: but if 3/4 of the states should thus agree to an amendment which would deprive the remaining states against their will of their equal vote in the Senate, would such amendment be binding? Answer: no. This case is provided against in the Constitution, and one other, in relation to slaves, which could only happen previous to the year 1808, but as that year is now past, no farther notice need be taken of it. Question: what is the supreme law of the United States? Answer: the Constitution itself is supreme, and all laws and treaties made by Congress and the President in conformity with it are superior to any law made by one of the states, so that if the law of a state contradicts a law of Congress, the state law is of no force, and the United States law alone must be obeyed. End of Section 1, Part 2.